The following is an informational program from the Sangamon County Circuit Clerk's Office. The information contained in this program is solely for the use of the people of Sangamon County to make them more aware of the services of the Circuit Clerk's Office. The employees of the Circuit Clerk's Office cannot give legal advice. Ladies and gentlemen, welcome to another edition of Circuit Clerk Presents. My name is Paul Palazzolo, your Sangamon County Circuit Clerk, and today we're being assisted by the team at the Capital Area Career Center, as always, and Director Paul LaMantia of the Digital Media section of the Capital Area Career Center, and students are directing and taping us today from Raymond Lincolnwood, Tri-City, Rochester, and Auburn High School. They're all visiting and working with us today to make sure today's program comes off as successfully as possible. Today's topic is small claims court, and with us is Judge Christopher Perrin. Judge Perrin is an associate judge for Sangamon County. He was appointed to the 7th Judicial Bench in 2008. Judge Perrin serves all kinds of cases. However, he's here today to give us a greater insight into civil small claims cases. In order to help those who may need to file a small claims case, our office, the Sangamon County Circuit Clerk's Office, has produced a small claims manual. This is available for free in our office and for you to view and print out on our website, which is sangamoncountycircuitclerk.org. And that website is all one word, sangamoncountycircuitclerk.org, and that's available to you both being able to pick that up in our office. We'd be happy to mail you a copy as well, or we can have you come and pick that up, or you can download it and print it off our website. So today, we're going to discuss small claims cases. And to begin with, Judge Perrin, first of all, welcome again. We're glad you're with us.
Thank you, my pleasure.
What constitutes a small claim?
Illinois defines a small claim as a civil action based in either tort or contract for money in not in excess of $10,000.
Is it a necessity to have a lawyer represent you when it comes to a small claims case?
Well, Paul, it's always a good idea to have legal representation in court. Persons 18 years of age or older do not have to have legal representation in a small claims court. If you're under the age of 18, you must have legal representation. Now, the rules for corporations and limited liability companies are slightly different. If you're a corporation or a limited liability company, you cannot file a small claims case unless you have legal representation. However, if you're a corporation or limited liability company and you're being sued in small claims court, you do not have to have legal representation. So again, you have to have an attorney if you want to be a plaintiff in small claims court as a limited liability company or corporation. You don't have to have an attorney if you're being sued.
Can a person file a small claim case to stop another person or a business from a service action or to return property?
The small claims court can only order a judgment for money. It cannot require a person or a business to do something or to stop from doing something. So if you're looking for some other type of relief other than a monetary judgment, you cannot pursue this in a small claims court.
Okay. Well, now, in that process, who would be considered the plaintiff and who would be considered the defendant?
The plaintiff is the person who brings the lawsuit or who initiates the lawsuit. The defendant is the person being sued or who is defending against the lawsuit.
And in that case, once that comes to a trial, who decides that case? Is there a judge or is there a specific jury involved too?
Most small claims cases are decided by a judge. However, you do have a right to a jury trial in a small claims case. If you want a jury trial, you must request this prior to the time or at the time you file your small claims complaint. Or if you're a defendant, at the time you file the responsive pleading. If a jury demand is not made at the time of the filing of the lawsuit or at the time that you file your answer to the lawsuit, the right to a jury trial is waived.
Can a person be sentenced to jail in a small claims case?
No, the small claims court can only order a judgment for money.
So we don't have to worry about doing any time in a small claims
Not
effort.
Unless you're found in willful contempt.
Okay, well, let's not do that. In the process, I mean, I've heard the term summons before, and that means, you know, in the courtroom. How does that apply in the small claims arena?
A summons is a court document that's issued by the circuit clerk's office, and it commands a defendant to appear in court for trial.
Can you recover court costs when you sue somebody?
Yes, you can if you win the case. The court may order the losing party to pay the costs of the winning party. So if you win your case, you can recover court costs. However, if you lose the case, you may have to pay the court costs of the winning party.
Wow. So if I'm interested in filing a small claims case, how is the defendant given notice of a small claims lawsuit?
Once the complaint and the summons are filed, they must be served on the defendant. Now, service is usually effectuated by the sheriff's office. The sheriff of Sangamon County would serve the summons and the complaint on the defendant by hand. However, you can also have a private process server serve the summons and complaint as well.
Okay. Well, I'm minding my own business. All of a sudden, I receive a summons. At that point, as a defendant, what do I do?
Well, in Illinois, as a defendant, you do not have to file a response to a complaint against you in small claims court. If you disagree with the claim made in the complaint, you simply show up to court on the first appearance date and explain to the judge that you deny the charges in the complaint. Now, it's important, however, that you show up for that first appearance date. If you're a plaintiff and you fail to show up, the court may dismiss your complaint. If you're a defendant and you fail to show up at a first appearance, a default judgment may get entered against you.
And that could be over with right there.
Yes.
If I'm the defendant and I don't show up, I'm out of luck right from the get-go.
Correct.
How long does it take to go from filing the case till it actually is the court time?
The first appearance is usually held 30 days from the filing of the complaint. Now, the trial is scheduled 6 to 8 weeks after the first appearance. Now, this timing can be effectuated by a number of factors. Whether or not, how long it takes to serve the defendant, whether or not there are any motions that need to be argued, do the parties want to participate in discovery, are there any continuances? Each of those factors could affect the timing by several months.
So what happens at the first appearance? Tell us that, for either party, the plaintiff and the defendant.
When your case is called, the judge will typically ask the defendant one question. Do you admit or deny that you owe the claim? If the defendant admits liability and agrees to the amount of damages, judgment will be entered at that time and there will not be a trial at any point in time in the future. If the defendant denies the claim, the case is going to get set for trial. In either instance, the case will not be tried on that date, but at a later date.
Okay. And so then what do you do to present your case as either the plaintiff or the defendant? Because you obviously need the opportunity as a defendant to say, hey, here's why. And that would happen at the actual trial, right?
That's correct. At the trial date, the burden of proof is on the plaintiff. And that burden is a preponderance of the evidence. And it means that the plaintiff must present proof that is more convincing than the defendant's proof. The plaintiff is given the first chance to present his or her case. And this means that they will tell in an orderly fashion their side of the story, including whatever evidence they have and whatever witnesses they have to testify. When the plaintiff is finished, the defendant will have that same opportunity to present their side of the story, including their witnesses and their evidence. The judge may choose to relax the formality of typically associated with trials, and they may ask questions themselves of the parties and the witnesses. Now, after both sides have presented their case, the judge will issue a decision, and that's called a judgment. And that is basically a court's declaration of how much, if anything, is owed.
So this is reminiscent of either like Judge Wapner or the shows that we've seen. You kind of witness a little bit of that sometimes, don't you?
You do.
That can be either amusing or frightening or all of the above. So in preparing for court as either the plaintiff or the defendant, what do we need to do to prepare?
There are a couple things you can do. First of all, make a detailed list of what happened so the facts are clear in your mind. Gather all documents that you have that may be helpful to your case. These could be things such as leases, contracts, notes, canceled checks, receipts, photographs, things of that nature. Determine if any witnesses will be helpful to you in your case, and if so, ask them to appear at trial. Now, if they won't appear at trial, at least voluntarily, you may choose to subpoena them to be at trial. Subpoena forms are available at the clerk's office. Note that written statements from witnesses may not be admitted at trial, so if there is a witness that is crucial to your case and they will not voluntarily appear, you may want to subpoena them, but they must be present in court to testify. Otherwise, the court can't consider that evidence. If you're suing on the basis of defective merchandise or faulty services, it may also be helpful to have an expert witness testify on your behalf. Finally, if you've never appeared in small claims court, you may benefit from attending court hearings in other cases as part of your preparation, just to get a sense of how trials are conducted. The clerk's office should be able to tell you how when those trials are scheduled.
So as a person preparing either as a plaintiff or defendant, I can go to other small claims courts, trials, and see how that's done a little bit.
The county courthouse is a public venue, and it's owned by the public, and the public are entitled to attend most court cases. There are a few exceptions, such as juvenile court, but for a small claims case, yes, you can absolutely attend other people's small claims cases.
What kind of time frame do I have as either a plaintiff or a defendant to make the case, to make, I mean, could somebody who's really trying to be obnoxious, could they go on for days? And how is the best way to say, hey, hold on?
A judge will usually give you as long as you need to present your case, as long as the evidence that you're presenting is relevant to the case.
Okay, so there really is no time limit per se. It can, okay.
Correct.
Can you ask the defendant questions? As the plaintiff, am I allowed to say to the defendant or ask any kind of questions? And what kind of questions normally have you heard for the plaintiff in that sense?
Yes, a plaintiff and a defendant will be allowed to not only present whatever evidence they have, but they're always entitled to cross-examine the witnesses of the other party.
Okay. Well, now let's say we've conducted the trial. We go through the whole process. What happens if I am the plaintiff and I receive a successful judgment from the judge? What happens from that point?
If you're a plaintiff and you win the lawsuit, a judgment will be entered in your favor and in the amount that is awarded by the judge. If you're a defendant and you win, judgment will be entered in your favor, indicating dismissal of the claim against you.
So after a successful plaintiff has gone through the process and the judge has entered in the plaintiff's favor and the defendant continues to be belligerent and not pay, what happens there? I mean,
well,
how can you?
First of all, interest begins to accrue immediately from the date of the judgment. And that interest is set by statute, and it's an annual interest rate of, I believe, it's currently set at 9%. But you have to collect your judgment. And as I tell people in court, obtaining a judgment in your favor and actually collecting the amount from the defendant are two entirely separate things. If after 30 days you've not been paid and the defendant has not filed a post-judgment motion or an appeal in the case, you may bring what are known as collection proceedings. Collection proceedings are legal proceedings, and there are many different ways to collect. There's a citation to discover assets, there's a third-party citation, there's a sheriff's levy, there's a memorandum of judgment that you can file against property, there are wage garnishments, there are non-wage garnishments. There are many legal ways to collect your judgment. However, as I tell people in court, collecting a judgment is much harder than actually obtaining a judgment, and usually requires numerous trips back to court.
Yeah, that's been, and probably more trial or more attorney expenses as well.
Exactly.
What if I believe, as either the plaintiff or the defendant, that the decision is incorrect? And you kind of mentioned appeal, the word appeal in the last answer. What happens at that point if I believe that the decision was incorrect, was wrong?
Whether you are a plaintiff or a defendant, if you think that the decision that decided at trial was wrong, you can either ask the judge to reconsider the decision, or you can appeal the decision to a higher court. Now, if you, whichever of those that you decide to do, they must be done within 30 days from the date of the judgment.
Okay, okay. Well, fascinating human nature elements of small claims court, particularly with an experienced jurist like Judge Perrin. We're going to take a break, and we have a few more questions of Judge Perrin regarding small claims court. So please don't go away while we enjoy this small commercial message.
Can I have a water?
Sure. Here you go.
Thank you.
You're welcome.
Oh, I hate my job.
You shouldn't hate your job. With the Capital Area Career Center, you can unlock your potential. With 17 programs, we offer you the chance to find the career that's right for you. CACC is the perfect alternative to your typical high school experience. Come by sometime and see what we can do for you. CACC, education that works.
Welcome back, ladies and gentlemen, to this edition of Circuit Clerk Presents. Again, my name is Paul Palazzolo, your Sangamon County Circuit Clerk, and today's episode of Circuit Clerk Presents is focusing on small claims court. And we've already had a discussion about the procedures necessary to make, as a plaintiff, to make a case to small claims court, how as a defendant can be involved in the process. We also made reference to this manual that you can ask for a copy from the Circuit Clerk's office or go onto our website, sangamoncountycircuitclerk.org, and go through the process of downloading this and make it available to you for the small claims court and making a claim as a plaintiff, or either defending your claim as a defendant, that you're either not into the claim or that you are into the claim. And we've already kind of talked about how you can appeal decisions, and with us is Judge Christopher Perrin. And Judge Perrin, on the if you believe the decision was wrong, we had kind of talked about the appeals process. And one question I didn't get a chance to ask before the break, what is that state or what level is the appellate process, and where is that decided?
A small claims case, if you're going to appeal it, you're going to appeal it to the appellate court for the state of Illinois. In this particular case, it's the 4th District.
Okay, and that's still, the 4th District is still locally headquartered here in Sangamon County.
It is. It's here in Springfield. So again, if you choose to appeal a decision from small claims court, either directly after trial or after an intervening motion to reconsider has been presented and considered by the court, and you want to appeal it, you must file a notice of appeal with the 4th District Appellate Court, and that must be done within 30 days following the decision that you're appealing. And
so that 30 days is strict. Once that 30 days passes, then forever gone.
Correct.
Okay.
Correct.
Can you take someone to court more than once for the same issue? And how is that? Let's say that, again, I thought that person, the decision was incorrect. I'm going to make a second go at it.
Not if the case was decided. If there has been a final judgment and the case is no longer subject to appeal, the matter cannot be raised again, either in the same court or in a different court. A court will use res judicata to deny reconsideration of the matter. Now, res judicata is a Latin term, and it's a Latin...
I had that for lunch today, res judicata. It's very good.
Res judicata is a Latin term, and it means a matter already decided. And under res judicata, a party is precluded from raising claims in any future litigation which were raised, or, and this is the important part, which could have been raised in that lawsuit. So it means that if you had a small claims case, and let's say you had 2 different causes of action, one was for breach of contract and the other was for negligence, and you only raised breach of contract, you cannot now go back and file a separate lawsuit for negligence based on the same set of facts that arise out of the same occurrence. You are precluded from raising not only the issue that you raised once before, but any issues that could have been raised in that same lawsuit.
So if a plaintiff didn't bring it up in the first go around, there's no chance of bringing it around again.
That's correct.
It's important to mention, ladies and gentlemen, about the fees for filing and the process for small claims court. Small claims cases can be filed at the Circuit Clerk's office with a graduated scale. Claims from $250 or less will cost $91. Claims from $2,500 to $10,000 will have a filing fee of $156. Now, this gives an idea of the costs to file a claim. And those are set by the Administrative Office of the Illinois Courts in concert with the Circuit Clerk's office. And we also have a full list of categories and costs that are listed in the small claims manual that I alluded to earlier. But what if, as a plaintiff, I can't afford the costs for filing to get the process started? where do I go?
There is a process in Sangamon County. I call it a fee waiver. If you qualify financially for it, you can go to the circuit clerk's office and pick up an application for a fee waiver. You'll have to fill it out. It asks you all sorts of questions about your economic condition. You'll have to sign it, and then you submit it back to the court, back to the clerk's office. Once the clerk's office receives it, they send it or forward it on to the judge who's been assigned to that case, and the judge will review it to see that you qualify. If you qualify, the judge will indicate that on the fee waiver, send it back to the clerk's office, and they will let you know that your fee waiver has been accepted. However, you have to pay attention. If you don't qualify, then you have to pay that filing fee or the appropriate filing fee. Otherwise, again, you may be defaulted at a later date.
And what about the defendant? If he or she is faced with costs that cannot be paid, what recourse do they have?
It's the same application, same procedure. So if you're a defendant and you're being sued, you request that same fee waiver, fill out the form, and it's the same process.
And normally, what's the time frame on that kind of that process?
That's a very good question, because a lot of times people will wait until the day of their trial to fill out that fee waiver. And if you wait till the day of the trial, it's too late. It's not going to get processed in time. Usually it takes several days for it to get from the clerk's office to the judge and then back to the circuit clerk's office again. So I would allow yourself a sufficient amount of time. If you think you don't qualify, if you think you do qualify for a fee waiver, my advice to you would be to fill it out immediately. Don't wait. Go to the clerk's office, get it, fill it out, and submit it so that it can timely be processed.
You know, many people probably are looking at this process as their first time to engage in the courtroom system. Help perhaps describe some courtroom etiquette principles that either a plaintiff or a defendant should engage in.
Well, the most important thing I can tell people is that they need to know when their court date is and what courtroom they're going to be in, and then be there on time. Once again, bring with you whatever papers, documents, things of that nature that you have that may support your case, and make certain that that it's organized and well thought out, and make certain that the judge has an opportunity to see it and review it. Once again, with witnesses, make certain that your witnesses are present with you in court. I have seen many times people show up to court and say, I have a witness who can testify to this, but they couldn't be here today, so I've got a statement that they've hand wrote out and they've signed it, and oh, by the way, I've had it notarized as well. The court can't consider that. It's hearsay evidence. If you have a witness who's important to your case, make certain that they're agreeable to be in court at that date and at that time. Also make certain that the witness knows which courtroom you're in and the appropriate time for it. We've had situations where witnesses have been in other courtrooms as well. So it's important that they're agreeable to this and that they know what they're, when and where they're supposed to be. The other thing I would, once again, subpoenas. If they will not willingly agree to take off work to be in court, you can always obtain a subpoena from the circuit clerk's office and require that they attend on the date of the trial.
Well, and unfortunately, this is probably something that has to be endured when disputes occur between individuals. However, I think the purpose of this program, as well as the materials that we have available for you on our Circuit Clerk website, is designed to help you be as informed as possible. And so we would again encourage you to review the Small Claims Court Manual that you'd be able to find on our Circuit Clerk website, or if you're interested in not only seeing it on the website, but also either downloading it or having us mail you a copy, we'd be happy to do that. But again, designed to keep you informed of the process so that you can know the courtroom etiquette, know that you're prepared by being informed, and hopefully work on being as successful as possible with either as a plaintiff or as a defendant to know what you need to do. Judge Perrin, thank you for joining us. We appreciate your willingness to help viewers be better informed, and we want to thank you for viewing this particular episode of Circuit Clerk Presents. Again, if you would like information on our website, SangamonCountyCircuitClerk.org. That's all one word, SangamonCountyCircuitClerk.org. So please, if any issues that you would need or any efforts that you would need for information, please don't hesitate to either go to our website or give us a call at 753-6674. A big thank you again to the team at Capital Area Career Center, students from Tri-City, Auburn High School, and Rochester High School, and Paul Lamantia, the director of the Digital Imaging Division at Capital Area Career Center. This is Big and Paul Palazzolo, your Sangamon County Circuit Clerk, with another issue of Circuit Clerk Presents. Thanks for watching.